Ever since Donald Trump made Cruz's eligibility a sticking point during one of the Republican debates, and to my great surprise, quoted me as having, I've never talked to the guy, as having concluded that Cruz's eligibility is far from settled, but is under a significant legal cloud. Ever since then, legal scholars of all stripes have come out of the woodwork to stake a claim on one side of the issue or another. Their conflicting views show just how unsettled the question really is. Despite the decision this past Monday by the Illinois Board of Elections to include Cruz in that state's March 15 primary, on the unbelievable ground that there has been a broad consensus in legal circles for over a century that everyone born to an American mother qualifies as a natural-born citizen, and that, to quote the Illinois Board in its legal expertise, quote, further discussion on this issue is unnecessary, so you can all go home. Well, that's breaking news, I must say, to quite a few constitutional scholars. For example, Professor Thomas Lee of Fordham University Law School, he did visit here, so maybe he's been infected by the Harvard bug, has recently concluded that Cruz is definitely ineligible because under common law at the time of the founding, a child born outside U.S. jurisdiction could not become a natural-born citizen through a U.S. citizen mother. It's only in 1934 that Congress eliminated the mother-father distinction from the statutes. From a more textual perspective, my colleague Einar Elhaeg has similarly concluded that Cruz just cannot be deemed eligible to serve as president under any legitimate form of constitutional interpretation. On the other hand, Brian Garner, a law professor who has co-authored a couple books with Justice Scalia, manages to find Cruz eligible by escaping the mother-father distinction and the problem of matrilineal descent through the 14th Amendment's principles of gender equality, the kind of time travel, 1868, inflecting the meaning of 1791. I do that myself. I love it. It doesn't sound very much like Cruz or like Justice Scalia. See, Garner's idea is that gender equality is part of the Constitution, although his co-author doesn't necessarily see it that way. That's doubly ironic, because Cruz's citizenship at birth definitely does not meet, and here there can be no dispute, I think, the Supreme Court's 1971 definition of a 14th Amendment citizen, which, to quote the amendment's language, gives citizenship status only to a, quote, person born or naturalized in the United States, unquote. Now, I'm not saying it would be indefensible to conclude through a hybrid form of interpretation that Professor Balkin has famously called living originalism, that somebody who's not a 14th Amendment citizen might nonetheless today be deemed a natural-born citizen eligible to run for president. I'm claiming only that it wouldn't be easy, and that it would, as David Strauss of Chicago argued in reviewing Professor Balkin's Living Originalism book, represent a kind of legal advocacy that doesn't necessarily engage with what makes one or another constitutional interpretation correct. Cass Sunstein's op-ed on this topic answers maybe to the question, is Cruz natural born as a citizen?